Lisa from TAL says today. You're probably well aware there's been significant changes in legislation regarding life insurance. Lisa was good enough to present to our advisors in Brisbane and absolutely knocked their socks off. It was one of the best rated presentations we had on the day. But not only is she a great presenter, she's certainly knowledgeable and works on the tech desk with Scott and David Glenn, and probably pushing them out of the way now and I think taking over the whole tech desk. You are South Australian based.
Absolutely. So I actually know a lot of faces in the room from the last 10 years. So exciting to see you all in my new capacity as part of the tech team.
Well, look, I don't think I need to introduce you. I'll just bugger off now.
So, hi everyone in WA, good morning. I'm certainly not Scott Hoger. I'm a whole head taller than him, just as a bit of a joke, but he is my boss, so I'll be really gentle. Look, like Mark said, we're actually going to talk this morning about the Code of Ethics. And I want to say, who's heard of the Code of Ethics? Yeah, everyone put your hand up because we're 17 months in and Michael's going to be noting down anyone who doesn't know what the FASIA Code of Ethics is. So a really good start to this morning. We're going to talk to specifics about two standards and they're quite important. They have been a little bit contentious and the industry's talked around what does this look like. And I'm hoping that we can give you a little bit more information today as to what's practical that you can take back and try to implement in your business in order to meet your obligations under these standards. We'll work with the technology this morning. It's beautiful. Yeah, no, it never does when you do. That's okay. We'll
I think it's
no.
I fixed it. I've done it.
As with every disclaimer, though, I will stress that this is our interpretation. So that the TAL technical team have spent a lot of time talking about FASIA. If you haven't been to one of our master classes and haven't done the exam, please jump on board, reach out and talk to Jade, our local BDM here today, if you need some help around that. But it's obviously quite interpretive, and the Code of Ethics at the moment is monitored, or your adherence to the Code of Ethics is monitored by your own licensee. So as the industry doesn't have a code monitoring body yet, your licensee is the one that's looking at how you're actually adhering to that and what you're doing within your businesses. So this is our best interpretation, and I'm sure your licensee will speak up if there's something any different. So we're going to talk about what actually is what we're calling free, prior and informed consent. We're going to talk about the clients that are affected, what you can actually do in your process, or what you might need to go back and look at within your process, and then some advice opportunities for you, because this is not all bad news. This is hopefully going to give you a better engagement with your customers to make sure that you meet your obligations, and that's just a win then, that you're going to have that much better level of engagement long term with your clients. So let's have a look at what free, prior and informed consent is. So this term came up as part of the introduction of the Code of Ethics. And like I said, this has been around from the 1st of January 2020. So we're 17 months in to people adhering to this Code of Ethics. And the Code of Ethics is obviously made up of the 5 values and the 12 standards. And, you know, it is quite interpretive. But what I want you to think about is that the code is an ethical overlay to what you already have to do as part of your legal obligations for corporations law. So corporations law is the base, and then you've got this ethical overlay provided by the Code of Ethics, the 5 values and the 12 standards, in which you need to also meet. And there's different rules for what happens when you breach either corporations law or obviously the Code of Ethics, and we'll talk through those later on today. But this is one that came into play, and free, prior and informed consent is a concept covered in both Standards 4 and Standard 7. And they're quite interpretive, and there has been some industry discussion around what this means and some concerns around existing clients that have insurance commissions. So legally, when we look at the terms for free, prior and informed, so free, we're talking about no conflicts here. We're talking about you and the client having a mutual understanding of the services that you're offering. And it has to be free of coercion, free of undue pressure and undue influence. You know, fraud has to be kept to the side. And you have to be really mindful that, you know, the client might have someone else in the room with them that is you know, putting the thumb on them and making, you know, decisions on their behalf. That might be someone who's, you know, might be an adult child with an elderly parent. You might have a client who's got a new younger spouse that's really pressuring them to do something. And You know, you have to be mindful of those situations. And as an advisor, you have to use your professional judgment to make sure when the client is giving you consent, it is free. When we talk about prior, this is one that's a little bit contentious, because what does prior mean? You know, when does prior mean? If you've got a client that's been a client, I know Phil's been around a long time. Thanks, Phil. You know, Phil might have had a client that's been his client for 10 years. Now, when is prior for that relationship between Phil and his client? And how awkward will it have to be to go back to that client now and say, actually, the rules have changed and now I need to re-engage you on a different level, even though we've had this relationship for 10 years. Some people have determined that prior might be before you provide them the SOA. But our interpretation is it potentially even be earlier than that. And you need to think about it in that context. Informed is obviously where you as an advisor need to use your professional judgment to make sure that the client understands what you're providing to them by way of services and the remuneration that you're receiving. And that's a really tough one, because your professional judgment can differ depending on the financial sophistication of your clients as to whether you think they're actually informed as to what's happening and able to make the decision about that next step in their relationship with you. And contract law actually provides us a really good example of that. And it's essentially says, unless there's a meeting of the minds, then you don't have that contract. So you know when you sit with a client for the first time, you know that you're on the same wavelength, and you'll know whether they're just not interested or you know it's not going to go ahead. You've got that gut feel. So essentially that's what you need to determine, that professional judgment and that level of experience that you have to make sure that the client is giving you that informed consent. So let's break down specifically the two standards. Now, standard 4, and this is directly from the Code of Ethics, you may act for a client only with the client's free, prior and informed consent. If required in the case of an existing client, the consent should be obtained as soon as practicable after the code commences. So for a new client, that seems fairly obvious. You can understand what to do for a new client. You know, you need to be talking to them at the earliest possible stage. But for an existing client, the term that FASI are using is as soon as practicable after the code commences. Now think about where we are already in the journey for the Code of Ethics. We're 17 months in. Have you spoken to clients already, and have you met with clients or done reviews or provided advice to clients where you don't think you've evidenced enough or have enough documentation or records to be able to evidence free, prior and informed consent in order to meet your obligations? So as soon as practicable, that's going to be an issue. You may need to go back and think about who you've spoken to over the last 17 months. Now, standard 7 is almost an add-on to that one. Standard 7 is talking about the remuneration associated with the services you're providing for that client engagement. And this is really important because it goes above the relationship you have with the client and the disclosures that you've made to them in your statement of advice, as an example, or above that of the FDS that you've sent them or the renewal notice that you've sent them. And again, FASI used the term as soon as practicable after this code commences. So standard 4 is the services. Standard 7 is the remuneration you're receiving for the services providing to the client. Now, there's obviously other obligations that you have under corporations law and under regulatory and legal obligations, things like privacy, and TASA has their own, but these specifically to the code. So a couple of things to think about, and these are not terms that TAL and our technical team have made up. These are actually contained within the explanatory statement. So FASI have been really good, unlike a lot of boring documents that I'm sure Michael and myself read. FASI provides some really good explanatory statements as to what they think these standards should look like. And they use some practical language. It's not too bad and easy, not too difficult, to understand. And they refer to 4 things. So when they say if you're trying to obtain free, prior and informed consent, these are the 4 things you need to think about: the services, the terms, the records, and the privacy. And these can be things that you now go back to your business and think about, can I evidence these in our business? Services, so specifically what services are being provided and how have you articulated that to the client? The terms, so the terms on which they're provided, and think about this in regard to timeframes. How frequently, how often, for how long, what period of time are you providing these services? What are those terms of engagement? What are the records that you're making? And is the client aware that you're making records of these? So, saying to them, I have to make file notes, I have to evidence this, I have to provide you a statement of advice, I have to keep this on file. Just making sure that they're aware that you have to keep these records. Now, they'll probably say that, yeah, that's fine, but it's important that you've had that conversation with them. They know that their information is contained within your client file. And that then leads into the fourth one, which is privacy. So you need to let the client know how you're keeping those records and that they are contained confidentially, and that you're keeping them secure. It might be electronic files, it might be still hard copy but locked in a cabinet in the back room. These are the things that you have to be aware of in order to meet your obligations for free, prior and informed consent. Now, just coming back to standard 7, and this is the remuneration one. This is where you need to make sure that the client is aware of what remuneration you're receiving. And this is really going to be a little bit harder for you where you're talking to clients that you've already had quite a long-term engagement with. And the rules for remuneration are changing. We're getting some changes again to renewal notices and opt-in and FDS later this year. But it's important that you make sure the client is aware of the services that are being provided and the remuneration that you're receiving. And you need to make sure that there's a clear and concise explanation. Don't just send them a document, make them repeat it back to you in your next review. I think if you're on the front foot about this remuneration, then you're less likely to receive objections from the client when you send them the next fee disclosure statement. You're less likely to get that next phone call from the disgruntled client saying, what am I paying for? Because you've been on the front foot around the services that you're providing and why you're being paid, what remuneration you're receiving for that. Think about this remuneration could be in multiple ways. It could be a fee for advice, it could be product fees that you're taking, it could be insurance commissions coming through. There's a multitude of things that you can be receiving across all types of products and services. So be really clear to the client. And when we're talking about that prior word in free, prior and informed consent, this is where it gets really difficult because you don't really know sometimes what you're going to be paid until you've provided the service. So you have to give the client an indication, and you don't have to give them a dollar figure or an estimate, but to be clear to them that say, if I'm going to provide you insurance advice, the way that we currently get paid for this is via an insurance commission. You have to make sure that they understand that up front before you go into the advice and provide that advice to them. So it doesn't need to be, like I said, it doesn't need to tell them exactly what the dollar figure is you're going to be paid yet, but you have to say, this is the way I'm likely going to get paid. Or you can say to them, we don't take commissions, we're going to charge you a flat fee for this service. Or we're going to charge you a paraplanning fee here, and then we're going to charge you an advice implementation fee and not take any commission on that policy. So you can give them a broad indication of how you're going to be remunerated for the advice and strategy you're providing. You don't need to give them that dollar figure, and that will help towards meeting that prior part of free, prior and informed. So let's look at actually what clients are impacted. Like we said before, new clients are a little bit easier because when you think about your initial engagement with a new client, it's likely that in that first appointment, you do have some conversation with them about how you're appropriately remunerated and what services you could potentially provide. So that's a little bit easier there. In the case of existing clients, so this is where the challenge is going to be for you. Because like I said before, if Phil's got a client who's had around for 10 years, sometimes it's a little bit awkward to ring them again and say, can you come in for your next review? And by the way, during your review, we're just going to have a little chat about the services I'm providing and the remuneration I'm receiving for that. So you have to be really careful how you're posing it with them. But you do have to have this conversation. So think about what you're going to be doing for those clients and how you're going to bring it up in your next communication or your next engagement with those clients. Now, we're talking here that the code of ethics applies to you providing services and receiving remuneration from retail clients. So it doesn't apply if you've got wholesale clients. Retail clients only that you're providing personal advice to. But I want you to think back to your client files and think back to what you might have on those client files now for your existing clients. Is there any sort of documentation in there that might be able to be used as evidence to demonstrate that you've obtained free, prior and informed consent? And we're not just talking about in the last 17 months. We're talking about even before that. So think back, how long have you had this relationship with the client and what's contained in there? Now, some of your clients will be back to eras where you didn't have to provide, documentation or anywhere near as significant paperwork as we do now. But it may be that you need to go back and tidy up those files. And like I said, meet with the client at the next possible opportunity and make sure you're covering the basis for providing this free, prior and informed consent. Now, when we're looking at standard 4 and we're looking at what's actually required for them, there's a couple of things I think you can think about. And one of those is like an ongoing advice fee. So for those of you that might have an ongoing relationship with a client, they know they're a gold, silver, or bronze client. They know what you're providing in the way of services, and they know what they're being charged and what you're receiving in regards to that remuneration. So that might be easier. But think about how you're actually going to evidence this. And this is where it's a little bit of free rein for you guys, because FASIA don't actually stipulate what documents you need to provide. They can say, so long as you can evidence free, prior and informed consent, you're going to be okay and you can meet this standard 4. So that's really great for you guys, because it means that you can start thinking about it in the context of all of the documentation that you keep for the client. So you can think about it in the context of the file notes you've taken about the conversation you had in that first meeting. You can think about it in the file notes you might have provided off the back of a strategy meeting that you had with the client. You can think about it in the context of a statement of advice and you have an authority to proceed signed, backed up with a comprehensive file note about what the client agreed to proceed with. Then you can think about it in the context of the opt-in renewal notice that the client signed and acknowledged about the services and the remuneration. So think about it in the context of all of this documentation can assist with you evidencing that you're meeting your obligations under standard 4. You don't need to create some sort of new documentation. We're seeing though advisors are favouring or interpreting this as an engagement letter. And we're not saying this is the be all and end all. An engagement letter is normally seen a little bit more in sort of professional services where you might meet with a lawyer and you talk to them about what you want them to do for you, and then they send you a scope of works, an engagement letter, and you sign it. And it kind of has their menu of pricing and you have an estimate of what you're going to be charged. That might be appropriate in your business. And you might determine that an engagement letter is going to be a better basis for you to evidence standard 4 and this free, prior and informed consent than just relying on the other documentation that you might have in a file, especially for your new clients. You might start it as a brand new process for new clients you meet from tomorrow, and you're going to have this engagement letter that they sign. So obtaining that free, prior and informed consent. The time frame is going to be really critical. And like I said, we're already 17 months in to abiding by this code of ethics. So go back and think about the clients that you've met and make sure that you can go back and talk to those clients and evidence appropriately this consent that's been obtained. Think about how often that you talk to the clients. Make sure that they understand this. And this is a really big one that obviously the regulators continue to look at and shine a light on for you guys is, are you contacting the client as often as you say you will, or as often as your services prescribe, because that's going to be a big no-no. Therefore, you may be in breach of one of these standards because you're not being able to evidence that documentation. Does the client understand what they're receiving? And I'll use a really good example here. In my relationship, my husband and I have been married 15 years. He's a chiropractor. He loves what he does, but not really great financially. If someone asks him a question, he just says, talk to my wife. She works in the industry. She's pretty smart on that stuff. And my accountant and my financial planner constantly just get documents signed back from me, emails back from me. They don't get a lot back from my husband. He signs what he needs to and sends it in, but I don't think my accountant or financial planner could actually demonstrate that my husband actually comprehends 100% what's going on and what our strategy looks like. Think about this in the context of how often you might only meet with one of the spouses in that relationship with your clients. How often do you meet business partners, but only one comes in for half the appointments? How often does someone turn up and say, my wife couldn't make it today, my husband couldn't make it today? Is that going to mean that you can't obtain free, prior and informed consent because you're only really communicating with one of the partners and you're missing the second partner or the second spouse that's really critical to meeting your obligations under this standard? It also applies if you work in self-managed super funds. If you have trustees, how many of the trustees do you meet with? Do you meet with all of the trustees or do you just meet with one? Think about this in the context of the parties that are involved, specifically for your existing clients and for your new clients going forward. So a couple of questions, and these came straight out of the FASIA explanatory statement. So when FASIA first put out their standards, the industry was able to respond, put some submissions forward. They were from licensees, they were from the AFA, the FPA, the AIOFP associations, all of the sort of associations responded. And there's a couple of key questions that came out. And FASIA responded in October last year, October 2020. They gave us some guidance around the code of ethics. So some questions that the industry asked that they provided comprehensive responses to. So the question was, does a code of ethics require advisors to seek annual renewal of the consent for all clients? And the great news is FASIA said, no, you don't. So they said you don't need to provide an annual consent for clients. So FASIA haven't specified a time frame in which you regularly need to go and continue to receive consent. So it's not like a renewal notice where you have a time period for 2 years and you need to get it done, or it's not like a fee disclosure statement you need to issue annually. They haven't given you a time frame to do this. So I'd be pretty comfortable in saying, so long as you can demonstrate it now and have evidence on your file of the client having given you free, prior and informed consent now, you'll likely be okay, but make sure you continue that ongoing when you have those regular contacts with the client. The one though that is a little bit contentious, and I'm going to focus on a little bit for you today, is in regards to insurance clients. So there was a question asked, I have a number of existing insurance-only clients who I have a regular contact with. These clients receive an advice document and are assigned all an authority when I presented the original advice a number of years ago. Do I need to contact them to obtain consent? And FASIA said yes. So I want you to think, if you are an insurance advisor and you have a number of clients on your book that are insurance or risk only, whatever you want to refer to them, you might think of them as transactional clients. You might only get on the phone to them once a year and say, hey, do you want to come in for a review? And they say, nah, it's all right, no worries. And you tick the box to say, yeah, attempted contact, or I've showed I've offered and they've declined. That is no longer going to be acceptable. If you are receiving insurance commissions, you will need to go back to these clients and obtain free, prior and informed consent. So this is different. Some of the legislation scopes out insurance. So you don't have to include insurance commissions in your FDS or your renewal notices. So that's fine. But all of a sudden, we've got this code of ethics. It says insurance commissions actually need to have the client acknowledge and give you free, prior and informed consent. So it's no longer going to be suitable for you to, like I said, get on the phone, say to the client, I'm offering a review, and they just go, no thanks, no worries, I'm happy with my policy. You now have obligations that may cause a bit of an issue for you. It's causing some issues for us as well as life insurers, because what are you supposed to do when you guys can now no longer evidence that you've received free, prior and informed consent? Quite often you contact the product provider and say, can you switch off the fees? Now, fund managers can do that quite easily. There's no fundies in the room. I'm sure they can. I know they can. But insurance companies really struggle. And part of that is we have legacy systems. And I'm sure Darcy's a bit the same. We work on dinosaur systems. And we have systems as well that can't just switch off the comms, because it actually is built into the pricing for the client. And then if we switch off the commissions, do we have to then reduce the client's premium, and we have legacy systems that really aren't able to handle that for some of our older products. So it might be appropriate that when you receive an insurance commission for these clients and you can't demonstrate free, prior and informed consent, you may need to rebate that to the client. You may need to seek advice from your licensee as to whether you need to stop that relationship with the client. But this is the game changer, because this is one, like I said, was quite contentious to start with. We're really nervous about insurance commissions, and FASIA confirmed in October last year it is correct. They need you to obtain free, prior and informed consent for insurance-only clients. Any questions on that? So I got a few from Brisbane sent back to me afterwards, and I've had to call a few people. I don't mean to be the bearer of bad news, but it's no longer appropriate under your FASIA Code of Ethics obligations. One of the things we've suggested at TAL is a risk review process, and it may be difficult to think about for your existing clients, but we'd like to say if you're meeting a new insurance client from today, here's what we might suggest as a really, really good time frame. So saying day one, your advice is implemented, the tele-interview application's gone through, policies in place, and off you go. We're saying it's appropriate to contact the client, touch base with them again, have a face-to-face review at the 12-month mark. You can talk about making sure they renew it for that second or consecutive year, any change of strategy. Make sure you're, again, going to obtain consent to continue that relationship, and make sure the client understands that if you're receiving a trail, it's going to continue when they pay that second year premium. We're also then suggesting it's appropriate to meet the client at the 3-year mark or the 36 months mark. There's an opportunity for you to say to the client, have your circumstances changed? Have you got married, divorced, had some kids, bought a house? It's a whole lot of life events that you can use as an approach to be able to engage and meet with that client. And again, tick the box to say you've received free, prior and informed consent. We're also suggesting that at the 5-year mark, or that 60 months is appropriate for you to again meet with the client face to face. And this is going to be even more critical going forward when these new income protection changes come in. You haven't heard, October this year, some massive changes to IP. There's going to be a 5-year contract policy, and the client will have to opt in to renew their policy for a further 5 years. So if an insurance-only client, that 5-year mark or that 4 years and 10-month mark is super critical. Now, it may also be appropriate for you to give them a call and have a chat at the 24 and 48 months, maybe do a virtual review or a quick phone call, but this is our proposed time frame. And this is really going to help you to meet your obligations here for this free, prior and informed consent, and be able to continue that relationship with your insurance clients. Now, a couple of questions. What happens where consent cannot be obtained? And, we're guided by FASIA again on this one. It says an advisor should take all reasonable steps to contact the client. If they're not able to confirm that the client provides informed consent, they should cease receiving the fees. So again, it may be appropriate that where you cannot demonstrate or obtain consent from the client, that you have to switch those commissions off or switch off the fees if it's another type of fund product. Is ceasing remuneration in the best interest of the client? Well, they're not going to know sometimes either way. If you can't communicate with them, it's going to be nonetheless, but it's going to mean that if you switch off that remuneration, you're meeting your obligations. Reasonable steps is also really quite difficult to define. We're not going to play in that space. I'm sure your licensee has some guidance for you on what that actually looks like, as to the level of communication, how many letters you have to post to them, how many calls you have to make. So long as that's appropriately evidenced, I'm sure, in your X-Plan or your tracking management systems, then that's going to be appropriate to say to your licensee or your compliance team, these are the reasonable steps that I've taken to try and contact the client. So a quick question. I want you to think about your own client base. Go back and think about your client base at the moment and your clients. How many would you be able to demonstrate free, prior and informed consent? What percentage of your clients do you think have appropriate evidence on file that right now you can say, I can demonstrate free, prior and informed consent? Is it up to 25%? Is it 26 to 50%? Is it 51 to 75? Or is it 76 to 100? So just by show of hands, A? Anyone say A? B? C? Everyone's looking, yeah, okay, great, Rob. Yeah, that's fantastic. The Brisbane guys were a little bit more nervous and they sort of said around the, maybe half. It's really hard. You have to go back and check your client files and make sure you can appropriately evidence free, prior and informed consent. And there's no right or wrong answer here because everyone's business is going to be different. But you need to start thinking about this, like I said, in context of new clients and your existing clients who are probably going to be a little bit more troublesome. So some opportunities for you and the process you can use. This clicker works. So think about this in the context of the initial engagement that you have with your clients. Like I said, FASIA don't stipulate a specific document, but the industry sort of favouring that initial engagement letter, and make sure you're bringing up with the client about the remuneration you're likely to receive. You don't need to give them the dollar figure from day one, but you need to start telling them about how the remuneration will be paid to you from the strategy or the advice that you're likely to provide to the client. It's easy to obtain consent when you're actually presenting the advice. That's probably the easiest piece of the puzzle, but your file notes can really assist in this process as well. And you need to make sure, obviously, you're meeting your obligations under corporations law, but specifically these two areas of the code, the Standard 4 and Standard 7. That authority to proceed when you actually provide the advice to them and start the process is going to be critical, because that's going to be an easier way for you to say to the client, they're giving me consent to receive these commissions, which I've disclosed in my statement of advice. But think about sort of anything else that you have to consider under that. Think about the detail in which you provide in that authority to proceed and the file note detail that you're providing as well. They have to get more comprehensive. And again, make sure you're meeting with the correct parties here and that they're not under any undue influence in signing these documents or giving consent for you to continue these services. And obviously that review is going to be really critical. So meeting with the client regularly, talking to the client regularly, especially those that are insurance only, are going to be the key here for you meeting your obligations. And think back to those 4 things that we talked about: the services, the terms, the records and the privacy obligations that you have. So make sure you're continuing to talk to the client about these 4 things. So I just want to touch on the opportunities here. Hey, animation, sorry guys. So advice opportunities for your existing clients. Like I said, it doesn't have to be an awkward conversation that you ring them and say, hi Rob, you've been clients of mine for 10 years. Regulations changed and I need you to come in and we need to have this awkward conversation now about the remuneration I'm being paid. You can think about how to engage the client and get them in by other means. So think about any clients that you might need to talk to about other things. So smoker to non-smoker is smoker to non-smoker is a huge opportunity for your insurance only clients. How many of your client base is still identified as smokers and you just don't know if they quit or not? That could be a huge change in premiums. When we look at binding nominations, at TAL, less than 20% of our actual nominations are correct at time of claim. Constantly paying people's ex-spouses or the wrong people, disgruntled adult children, all sorts of mess. So binding nominations are a great way to lead the conversation with your clients, get them in, update it to the appropriate circumstances, and then you've got a reason to engage with them, and then at that time you can obtain that free, prior and informed consent. Also think about the upcoming IP changes. This might be a real good one to get the client in the door now before October and make sure that you're updating their IP contracts before things change for the worse in October. So I guess that the key point here is to lead with those advice discussions. Don't lead your engagement or re-engagement with the client around, hey, Mr. Client, you need to come in because we've changed the process and regulations changed. Lead with the advice discussions. Have your circumstances changed? Come in and have a chat with us. We need to update some things. And in the process then of doing so, you can obtain this free, prior and informed consent again. So that's all from me. I know it's been a bit of a whirlwind tour of Standard 4 and Standard 7. But like I said, I think it's important that you get your head around this and make sure you can appropriately evidence what this means. Make sure you've got contained evidence in your existing client files when your compliance team come knocking to say, can you demonstrate free, prior to informed consent? You want to be able to say yes for 100% of your client base. If you do want to know more though, please reach out to ask an expert at tal.com.au. That's the best way to contact myself and the TAL Tech team, or else Jade your BDM. But I'm happy to take questions for a minute or two if I have time. Yep, Rob?
With regards to IP and the 5-year contract, is that going to be retrospective or is it from new?
So new
contracts?
customers only
Yep.
from 1st of October. So your existing clients with IP now are grandfathered. If you want to know more, the Risk Academy has a Future of Income Protection webinar. So thank you very
Thanks,
much,
Lisa.
guys. Much appreciate your time.
I think we're